Good day, everybody. This is Michael Leveris from juristu.com, a legal network with our participating attorney, Gregory Spektor from the law firm of Gregory Spektor and Associates, a premier law firm that deals with personal injury and personal injury only, car accidents and construction accidents. Gregory, welcome back.
Good morning, Mike. Thank you for having me. Thanks.
Gregory, I called you in because there was a big development that happened recently in courts, which could change the landscape of personal injury lawsuits here in New York. There was a certain doctor, Dr. Tusi, who is an expert for the insurance companies, right? And insurance companies are using him to try to not pay for insurance claims, which is not good for the people who got hurt in car accidents. They're trying to get recovery for their injury, for their medical bills and so on. Because of this doctor, they were being precluded. So please tell me what happens and how can this help now the plaintiffs, the people who are suing, to get just awards for their injuries.
All right, so yes, this was factually correct. There was a lawsuit on June 7th that ended up in a what's called an excess verdict.
Okay.
What's an excess verdict? Let's start from that. Now, insurance company has a particular insurance limits. And the most common insurance limits in the state of New York are 100, 300, which means that $100,000 for each person who is in the car, who is involved in an accident, up to $300,000 total.
Okay.
So let's say 3 people may potentially get 300. However, 5 people will have to divide those 300 between them. Now, there are some insurance companies that were notorious for never ever tendering that amount, and they would have a bunch of steps that they would go through in order to not pay that amount. And I'll be honest with you, there were a lot of law firms that wouldn't take cases once they would learn that this insurance company is the defendant. We were not one of those firms. We were taking these cases. We know how to fight them. We know the variables that need to be solved.
And you have a whole army of attorneys and paralegals ready to go to fight for your clients.
Exactly. So of course, first, they try to do, while the litigation is going on, they put out that ridiculous offer of usually $25,000, and they wouldn't move from that. You don't take it, they start trying to dismiss this case on the motions. If the liability is an issue, they'll try a motion for summary judgment on liability. Then they would try a motion for summary judgment on threshold. Now, I guess let me try to translate that in plain English.
Please.
Let's say summary judgment. Summary judgment is when, one party says, listen, there is really no issues of fact to be presented to a jury. These issues are issues of law, and therefore they can be decided by court, by a judge. Okay, so you go ahead and file such motion. We do that a lot on the liability side, especially if it's a rear-end collision or it's an obvious violation by the defendant of a VTL rule, a stop sign or a left turn, things of that nature. The advantage for plaintiffs in obtaining such a judgment early on in the game is that it starts accumulating interest of 9% annually. And then whatever the verdict is at trial, it has to be adjusted by that 9% annually from the moment that the judgment was granted. Okay. Now, honestly, rarely will the defendants succeed on their motion for summary judgment for liability, because you and I, no plaintiff's lawyer will take a case where there is a questionable liability. Why? Because we get paid on contingency, right?
Only if you win.
Only if we win, right? So the next motion that they try to do is motion for summary judgment on threshold of seriousness of the injury. What does that mean? Now, New York State has a very narrow definition of what constitutes a serious injury. And that, includes a fracture, laceration, loss of limb, loss of fetus, death. Then if you were not able to attend to your day-to-day activities for the first 90 days, for 90 days out of the first 180 days immediately following the accident. And then more commonly used are significant, permanent or significant limitation of body use or organ. Now, and that is where that particular insurance company, I'm not going to name it, would throw those motions at everybody. And sometimes they would succeed. At the very least, it requires a lot of work to oppose that motion because you need to get affirmations from all the doctors. You basically have to put the client through sort of another medical exam just to beat this motion.
Right.
Throughout all the doctors. But we have never lost that motion ever against that particular defendant. So when all this fails and they go to trial, they like to put, and you called him a doctor, you're being generous. He is a self-proclaimed doctor. He has his medical degree in another country, which does not count in the United States. He never, ever, he never completed his affirmations here.
Unbelievable.
At least in the state of New York. And they would provide this doctor's opinion. He was called a biomechanical expert. And usually that person would review the, pictures, defendant's vehicles, pictures,
the charts.
Pictures. He would review the testimony of the depositions, and he would review all the treatment. And always he would say that these injuries could not have been caused by this accident, which creates...
So always, as a rule, he would make sure that the plaintiff does not get paid. Always.
You understand, he was not an independent consultant.
He was paid by the insurance company.
He was paid by insurance companies to give that opinion.
Okay.
And unfortunately, it was not just this particular insurance company that used them. He was, this name is very well known. I went against this guy about 3 years ago in King Supreme. I'm sorry, actually, it was transferred to King Civil, and destroyed him on the cross-examination. Unfortunately, the client didn't want to wait until the verdict because they offered $95,000 before jury went to deliberate. We took that $95,000. What happened on June 7th is, you're right, is a game changer because I guess that client didn't mind going above and beyond, and they got a verdict of over $1 million on $800,000 policy. Now, what that means is that a lot of times when insurance companies do not try to settle the case by, in a lot of instances, when the injury is serious enough, tendering the full policy, then the plaintiff has potential cause of action for bad faith, for that excess. In other words, for the difference between the verdict and the available policy.
Wait a second. So I just want to make it clear. The policy was, you said 500,000?
No, $100,000.
100,000. But the jury gave the plaintiff $1,150,000.
Correct.
Unbelievable. See, I never knew you can go above the policy limit.
So it's not a straightforward, it's not that they have to pay now. You have to file a new action.
So it's possible to get paid.
Yes, it's very much possible. You need to do a few things beforehand. For example, you should, as a plaintiff's attorney, you should send what's called bad faith letter, telling the insurance company that at this point you're no longer acting in good faith to protect your insurer. You have to put your insured on notice that you're not acting in such a way. Ask him to get their own counsel, because we will be asking the jury for a verdict far in excess of available policy.
Gregory, this is a very interesting piece of information, and I'm going to ask you to come back another time. We're going to do a whole separate piece just on that, because that's very interesting. You could get beyond the policy limit. But let's come back now to this demolished, destroyed Dr. Tusi.
Right.
Doctor,
So
in quotes.
a lot of times, so what was, it's not a secret that plaintiffs' attorneys, they talk to each other.
Right.
There are a lot of listservs out there. There are a lot of conferences where plaintiffs' attorneys interact and discuss, and everybody was mad that insurance companies are trying to put that hack. I'm sorry. And at this point, I don't think I'm I'm crossing any lines, because once those transcripts become available, everybody will see that he was.
So what happened in that courthouse?
So let me just pull back. So the attorneys talk amongst themselves, and there was a division as to what's better, what is safer way to proceed. Is it to preclude this alleged expert, through what's called a motion in limine, which you can file right before the trial starts. And in that motion, you can indicate whether or not what he reviewed is not sufficient to form that opinion. Or there is also what's called a FRI hearing, which is a hearing where you honestly, you basically question all the background that this person presents he has.
If he's a real expert.
If he's a real expert, and even if he proves that, as to whether or not he actually applied his expertise diligently to the facts of this case. And like I said, first we destroyed him on the cross-examination. We've precluded him many times on this motion in limine. We precluded him at least once on that FRI hearing. And the argument amongst plaintiffs' lawyers was whether or not was the best way to do this. Is it safer to preclude him just in case, just to make sure that jury do not hear this opinion and it doesn't poison their way of thinking, or put him out there and destroy him on the cross-examination? Well, now that issue is resolved.
Okay. How?
Obviously, because now these transcripts from the hearing of June 7th will become available. And all the transcripts from any trial are public information. You can exchange them. And now if anybody is going to try to bring the same expert, what you're going to do is you're going to read from that transcript all those questions, all those answers that he got wrong. You can ask him, do you know what was the jury award? And he's going to have to tell you. If not, you can go ahead and tell it for him.
So basically, he is forever tainted. His reputation is tainted.
In my opinion, he's done. In my opinion, he's done.
Well,
moreover, I'll be honest with you, Michael, since June 7th, we started seeing that insurance company calling and trying to settle the case. At first, I didn't understand what was going on.
They realized what happened.
They would never, ever go above $25,000 until you start selecting the jury. And I had a case, it was supposed to go for jury selection on June 14th. They call us on June 10th, and before even trying too hard in front of the judge, they're putting out. I'm going to ask you something.
Are you able to disclose who is that insurance company? What is it?
I am. I don't think this is.
Let's hear it.
It's American Transit. That's the insurance company that insures most of the yellow cabs.
Listen up. If you listen to this video, if your policy carrier is American Transit, and before you were unsuccessful to get paid for your bodily injury, now it is possible. It's not guaranteed, but I think it's worth a shot, right?
It's a lot easier, yes. And
so, Gregory, this was
it's not your insurance. I just want to clarify one thing. It's not your insurance, but the insurance of the tortfeasor, the insurance of the defendant that caused you to suffer those injuries. If before that, a lot of people would say, don't even bother.
Right.
Now is the time. Now is the time.
Gregory, this was a great takeaway here, that this was a score, a win for the good guys, for the attorneys who prosecute these plaintiff cases, for the people who get injured and trying to get what's rightfully theirs, trying to
I
get
think so.
compensation so they can become whole because of loss of work, damage to the car, medical bills, bodily injury. Now there's more avenues available to get
It brought the balance. It brought the balance where it should be. That
Right.
the insurance companies should not be just in the business of making money. Where,
Right.
well, obviously
That's a
that's
great
it. But
point.
they have to fulfill their
Yeah,
positions and
this is why
compensate people
we
for their
pay
injuries.
our insurance premiums.
Premiums,
In anything
premiums for
happens,
sure.
we get covered. Okay, Gregory, this was good news. Thank you for bringing them to us. We appreciate it. If anybody has any questions about their case, about a car accident issue or construction accident issue, please call the number at the bottom of the screen. Ask for Gregory Spektor, and Gregory, you'll be able to give them free consultation about their rights, of whether or not and how they can get paid for their bodily injury. Gregory,
Absolutely.
thank you. Everybody, have a great day. Thank you for tuning in. Until next time, take care.
Thank you, Michael.
Thank you. Bye-bye.